Welcome, listener, to the Deep Dive. Today we're digging into something absolutely fundamental in criminal law. The line between just thinking something bad and actually doing something criminal. You can wish all sorts of things, but the law generally doesn't step in until there's an action. So the big question for you is, when does that internal thought, that intent, actually cross over into conduct the law recognizes as a crime? What counts as a criminal act? Or, maybe even trickier, when does not acting become a crime?
That's exactly right. And to get you a clear answer, we really have to break down the physical side of crime. There are three key pieces we need to analyze. First, there's the voluntary act requirement. Lawyers often call it actus reus. It's the action itself. Second, we have to look at the rules for omissions, meaning failures to act. These are pretty specific situations where not stepping in is the crime. And finally, we tackle concurrence. This is about making sure the bad act and the bad thought, the mens rea, happen at the right time, legally speaking.
Okay, let's start with that first pillar then. The voluntary act. What exactly is a criminal act in the modern legal sense, and why this emphasis on it being voluntary?
Well, the modern definition, especially influenced by the Model Penal Code, is actually quite narrow. An act has to be a voluntary bodily movement. That means things like just thinking, or the circumstances around something, or even the results of an action. Those aren't the act itself. And the voluntary part is critical because, well, think about it. If you can't control the movement, say, a reflex or something you do while unconscious punishing it, doesn't really achieve anything. It doesn't deter that person or anyone else, really. So no deterrence, no real basis for retribution either.
Okay, that principle sounds clear enough. But where does it get fuzzy in practice? What kinds of movements do lawyers argue, and courts agree, aren't voluntary?
Yeah, there are some standard categories the law generally recognizes as involuntary. Four main ones usually come up. First, a reflex or convulsion, like a knee-jerk reaction completely outside your conscious control. Second, any movements you make while unconscious or asleep. Think sleepwalking, or maybe actions during a severe seizure. Third, acts done under hypnosis or because of hypnotic suggestion, that's generally seen as not truly voluntary. And fourth, if your movement is physically forced by someone else, like if someone grabs your hand and makes you hit another person, you haven't performed the voluntary act. They have. The key is whether the movement comes from the actor's own effort or will.
Right, that point about sleep. That seems like a perfect test case. Let's analyze Fain v. Commonwealth. First, what are the legally dispositive facts?
Okay, in Fain, the defendant was charged with murder. The killing happened while he was either asleep or in that, foggy state right between sleeping and waking. His defense was basically, I wasn't conscious, it wasn't voluntary.
And what was the core legal issue the court had to decide?
The main question was whether killing someone while you're unconscious or asleep could actually satisfy that necessary element of a voluntary act for a homicide charge.
What rule did the court apply to figure that out?
But they applied the fundamental rule. Criminal liability needs a voluntary act, and actions taken while unconscious or asleep, those are considered non-volitional. They don't count as the required actus reus.
So how did the court connect that rule to the facts? What was the court's analysis?
Well, the court reasoned that even if, say, a sleepwalker's actions look like they have a purpose, maybe reflecting some unconscious desire, the law shouldn't punish that because the person isn't in control. If the law demands a voluntary act, you can't be guilty of murder just because some unconscious impulse surfaces while you're asleep.
And the conclusion. What was the final outcome for Fain?
He was found not guilty of murder based on the lack of a voluntary act. But, and this is important, the court left the door open a bit. They suggested liability could arise if there was some earlier voluntary act. For example, if he knew he was prone to violent sleepwalking and, despite that knowledge, voluntarily chose to sleep with a weapon nearby. That prior choice could potentially show recklessness for maybe a lesser charge.
Wait a second. So we're shifting from punishing someone for doing something wrong to potentially punishing them for not doing something. That feels like a really different basis for liability. You mentioned omissions. What's the absolute necessary condition before a failure to act can even be considered a crime?
That's the crux of it. A law is generally hesitant to force people to act, even to help others. It values individual autonomy. So for an omission to lead to criminal liability, there absolutely must be a pre-existing legal duty to act. It can't just be a moral obligation, feeling like you should help. This legal duty has to come from somewhere specific, like common law precedent, a statute, or maybe a contract.
Okay, so if the general rule is no duty to rescue a stranger, Where do these legal duties actually come from in common law? What are the specific situations that create this obligation?
Right. The common law carves out specific exceptions based on recognized relationships or situations. There are generally 5 main categories where this legal duty arises. 1. Relationship. Think parent-child or spouses. There's an assumed dependency. Interestingly, this usually doesn't automatically extend to, say, adult children having a duty to care for parents or siblings for each other. 2. Statute. Sometimes laws explicitly require action, like hit-and-run laws that demand drivers stop and provide aid after an accident. 3. Contract. If your job or an agreement requires you to act like a lifeguard, a paid nurse, or maybe a railroad crossing guard. 4. Voluntary assumption of care. This is key. If you choose to start helping someone who's helpless, you generally have a duty to continue, especially if your stepping in might have stopped others from helping. And 5. Creation of the peril. If you're the one who put someone in danger, even totally by accident, you then have a legal duty to take reasonable steps to help them.
Let's test that last one, creation of the peril. Let's analyze Commonwealth v. Cali. This case seems to mix an accident with a later deliberate inaction. First, what are the legally dispositive facts?
In Pali, the defendant accidentally started a fire in his own building. He realized it was burning, but then he deliberately did nothing. Didn't try to put it out, didn't call for help. Why? Because he decided he wanted the building to burn down to collect the insurance money.
And what was the core legal issue there?
The issue was, could his failure to act the omission count as the physical act needed for arson, especially since his criminal intent, the intent to defraud, formed after the fire had already started accidentally?
What rule did the court apply, particularly about the duty?
The court essentially applied 2 rules here. First, they found he did have a legal duty to act because he had created the peril, he started the fire, even though it was accidental. Second, they applied the rule of concurrence. The criminal intent has to exist at the same time as the criminal act, which in this case was the omission.
Okay, so walk us through the court's analysis. How did they link his accidental starting of the fire to his later decision not to act?
The analysis was that, yes, the start of the fire was innocent, but the criminal conduct wasn't starting the fire. It was the later intentional failure to act once he knew about the danger he'd created. That omission, not calling the fire department, not trying to put it out, happened precisely when he had the criminal intent to let it burn for the insurance money. The act, or omission, and intent lined up.
At the conclusion, was he guilty?
Yes, he was found guilty of arson. The court concluded that his criminal omission, failing to act on his duty, concurred with his criminal intent to defraud. Without that duty arising from creating the peril, just wanting the building to burn down after it accidentally started wouldn't have been enough for arson.
Okay, let's push on these ideas with some hypotheticals. These can really test the boundaries. First one, imagine a parent who is extremely poor, facing charges for criminal non-support because they failed to provide food and shelter for their child. They argue, I literally could not afford it. Is impossibility a valid defense here?
It's a tough situation morally, but legally, that defense usually fails. Criminal law impossibility typically means actual physical impossibility, like you were physically restrained and couldn't act. Financial inability generally doesn't count as absolute impossibility. Courts, like in the Sturz case mentioned in the sources, often say that if there were any available avenues like seeking help from welfare agencies or charities and the parent didn't pursue them, then they can't claim impossibility. They were physically able to seek aid, even if they couldn't personally pay.
All right, now for a real classic head-scratcher, the mistake is to death scenario. This really tests concurrence. So person A wants to kill person B. A hits B over the head, B falls unconscious. A thinks B is dead. To cover it up, A rolls B's body off a cliff, planning to make it look like an accident, but B wasn't actually dead from the blow. B dies later from exposure at the bottom of the cliff. When A rolled the body, the intent wasn't to kill, but to dispose of a corpse. Can A still be charged with murder?
Ah, yes. This is a famously tricky one for concurrence, because technically the intent to kill happened with the first act, the blow, which wasn't fatal. And the fatal act, rolling the body, leading to exposure, happened when the intent was just, disposal. Despite that apparent mismatch, most courts do uphold murder convictions in these cases. They often use a single transaction or continuous act theory. Basically, they view the whole sequence from the initial attack to the disposal as one continuous event driven by the original intent to kill. Analytically, probably the best way to look at it is causation. Was the first act, the one done with intent to kill, a substantial factor, a legal cause of the eventual death, even if the mechanism was different than planned? If yes, then murder holds.
Okay, that single transaction idea helps. Let's formalize this concurrence requirement then. We've seen it pop up a few times. What does it really mean for the mental state and the physical act to concur?
Right. Concurrence isn't just about the thought and the act happening around the same time. It's more specific. The mental state, the mens rea, has to actuate or drive the physical conduct, the actus reus. The bad thought has to be the reason for the bad act, essentially. So if you accidentally knock over your enemy and then you feel happy about it, that later feeling doesn't make the accidental act a battery. The intent didn't cause the act. It came too late.
Okay, let's use People v. Green to see this in action, especially where force comes before the intent to steal. What are the legally dispositive facts in that case?
In Green, the defendant first used force, killed or knocked out the victim, but for reasons other than theft. Maybe it was anger, revenge, something unrelated to stealing. It was only after the victim was already down and helpless that the defendant then decided, hey, I'll take their wallet or whatever valuables they had.
And what was the core legal issue?
The issue was whether that initial violence, which wasn't motivated by theft, could satisfy the force or intimidation element required for the crime of robbery, given that the intent to steal only popped up after the violence was over.
What rule did the court apply regarding robbery and concurrence?
The court applied the strict rule for robbery. The force or threat used must concur with the intent to steal. That means the force has to be used for the purpose of committing the theft. You can't form the intent to steal later and have it retroactively applied to earlier violence.
How did the court reason through that? What was the analysis?
The analysis focused on why the force was used initially. Since the first act, the violence was driven by malice or rage, not by an intent to steal. That crucial link, the actuation, was missing. The intent required for robbery didn't drive the force. The later intent to steal only coincided with the act of taking property from someone already incapacitated, which isn't robbery, legally speaking.
And the conclusion.
Yeah.
What was the outcome for the robbery charge?
The defendant was found not guilty of robbery. The necessary concurrence between the force element and the larcenous intent just wasn't there. Now, they could still be guilty of the initial homicide or assault, plus simple larceny for the actual taking of the goods, but not the aggravated crime of robbery.
That distinction is critical. Okay, let's pull all this together now. For the listener trying to spot these issues, maybe on an exam or just analyzing a situation, can we create a kind of step-by-step diagnostic checklist for actus reus?
Absolutely. We can boil this down into a pretty reliable 4-step process. If you run through these checks, you should be able to spot the key issues related to the physical act requirement and concurrence. Step 1. Identify the physical conduct. First things first. Is the conduct we're looking at a positive act, someone actually doing something, a bodily movement, or is it an omission, someone failing to do something? Step 2. If it's a positive act, check voluntariness. Okay, so they moved. Was that movement a product of their own will or effort? If it looks involuntary reflex, sleep, forced by another, then you immediately have to ask, was there an earlier voluntary act that connects? Like the person with epilepsy who chose to drive, knowing the risk. That earlier choice might supply the needed element.
Okay, that covers acts. Now, if step 1 tells us it's an omission, step 3 is about duty. How is checking for duty different from checking for concurrence later in step 4?
Good question. They test distinct things. Step 3 tests whether an actus reus exists at all for an omission, while Step 4 tests the timing relationship between that actus reus, act or omission, and the mens rea. So Step 3. If an omission, check for legal duty. This is the gatekeeper for omission liability. Does the person fall into one of those 5 special categories? Relationship, statute, contract, voluntary assumption of care, or creation of the peril. If there's no legal duty, then there's no crime based on the omission. End of story. Doesn't matter what they were thinking. Step 4. Check concurrence. Assuming you do have a voluntary act or a legally recognized omission with a duty, now you check the timing and connection with the mental state. Did the required mens rea exist at the moment the criminal act or omission happened? And crucially, did that mental state actuate or drive the conduct? This is where you watch out for those tricky sequences, like the mistake as to death cases, to make sure the bad intent didn't come too late.
That framework really clarifies the process. So we've seen that criminal law fundamentally punishes the choice to act criminally. Not just having bad thoughts or being in a certain state, but defining that choice, especially when it involves not acting, gets complicated fast. And it brings up a fascinating point. We were talking about how Anglo-American law, the basis for the U.S. system, is very restrictive about forcing people to rescue others, really emphasizing individual liberty. But, many European countries have what they call Good Samaritan laws.
These laws do impose a general duty to help someone in serious danger as long as you can do it without putting yourself at risk. So here's a final thought for you to chew on. If our legal system values action and consequences, why is it often so resistant to turning a strong, clear moral duty to help, especially when helping is easy and safe, into an actual legal duty? What does that say about our balancing of individual freedom versus collective responsibility? That wraps up our deep dive into the physical requirements of crime for today. Thanks for joining us.